73%. 73% of a federal witness statement has been redacted, deleted, destroyed before it reached a congressional committee. And when Jasmine Crockett put that document on the table and asked Patel a single question, who authorized this? The answer she received was not an answer. It was silence. Then the lawyers, then evasive words, and finally the unexpected. The right to rely on the Fifth Amendment. Against a document classification question, against an administrative procedure question, against the question of who looked at this file. Watch this video until the end, because today, Crockett cornered Patel with 4 documents, 4 questions, and a 72-hour deadline, leaving him unable to respond. And when cornered, Patel's weapon of choice was the right to remain silent. This was not a routine inspection hearing. This was a trap, and the trap worked perfectly. Rayburn House Office Building, room 2146, Tuesday afternoon. The hearing had been going on for about an hour. Standard questions, standard evasions, the usual rhythm. Witnesses provide carefully prepared non-answers while Congress members pretend to be satisfied. But Jasmine Crockett didn't come to play that game. Because Crockett is not a career politician. He was a public defender and civil rights attorney in Texas. He interrogated witnesses who were clearly reluctant to answer for years. And today he walked into room 2146 with a blue folder. There was a single document inside, an FD 302. The FD 302 form used within the Federal Bureau of Investigation is a fundamental documentation tool where agents record witness interviews and statement summaries in a standardized manner during federal investigations. Names, dates, and significant events conveyed in each interview are written in a specific format, and these records form the official backbone of the investigation file, serving as a reference in subsequent analysis and judicial processes. That's why what happens to this document is so important. The witness in question had testified about the Epstein investigation, especially about financial transactions. Wire transfers flowing between accounts, large sums of money connected to individuals named in sealed court documents that the FBI has fought to keep secret for years. That statement had to reach Congress. Federal law requires it. The oversight authority demands it. But by the time the document reached Congress, 73% was gone. It hadn't been lost. It hadn't been deleted. It had been redacted. Crockett lifted the document. The cameras came into focus. Page after page of black lines, deleted lines, lost paragraphs. A federal witness statement had been replaced with a censorship exercise. Crockett's voice was calm and professional. Director Patel, who authorized these blackouts? A simple question, directly. The kind of questions that every member of Congress has the right to ask while reviewing oversight documents. Patel did not respond immediately. His lawyer leaned forward, whispering something. Patel's expression tensed, and then he said he needed to consult his lawyer before answering. But there's a notable detail here. The question, who authorized it, is not complex. It does not require legal advice. If Patel knew the answer, he would have said it. If he didn't know, he would have said that too. But he didn't say either. He brushed them off. And Crockett didn't let the dodge pass, because he had come prepared. He pulled out a second document from his folder, a privilege log. The FBI must explain why it redacts everything in a document sent to Congress. An official index linking each redaction to a legal justification. Crockett placed the privilege log next to the redacted FD 302, and he showed the unexplained to the commission. Every single financial reference in the witness statement, every wire transfer, every account number, every transaction timestamp was redacted with the same code. Code D. Director Patel, said Crockett, what does Code D mean? Patel winked. His hand went down to the table, pressing his fist. I'm not familiar with that specific description, he said. Not familiar. The FBI director, the person responsible for overseeing the classification and transmission of documents to Congress, was unfamiliar with a code that appeared 47 times in a single privilege log. Crockett did not raise his voice. It wasn't necessary. Code D appears 47 times in this log. Each single instance corresponds to a financial transaction referenced in this witness statement. I want to know what it means and who authorized its use. Patel said he needed to review the internal procedures. Translation: he wouldn't respond. And at this point, the situation took a different turn. Crockett issued the third document, an internal FBI note dated 6 weeks before the redacted FD-302 was sent to Congress. Subject line: Epstein file review classification update. Final. This note was no Crockett. Slowly read the note into the official record. The note had been written by a senior official in the FBI's Office of General Counsel. One of these individuals now held a prominent position in the current administration. Director Patel, did you personally review this note? 30 seconds passed. 30 seconds in a courtroom feels like a lifetime. The camera zoomed in. All eyes were on Patel. Finally, he spoke. As far as I can remember, I hadn't personally reviewed that note. As far as I can remember. This phrase does a lot of work. It implies uncertainty. Maybe he reviewed it, maybe he didn't. But the question is, the FBI director didn't review this note. So who did? Crockett asked exactly that. If you say you didn't review it, director, who did? Patel's response: I cannot speak to the internal deliberations of the Office of the General Counsel. Washington speak. This means someone made this decision, but I won't say who it is. And that's when Crockett produced the fourth document, a document chain log. This FD-302 was accessed 6 times within 30 days. 6 times. Not dozens, not hundreds, 6. The last access was at 09:47 that Monday morning. Less than 3 hours later, a redacted version was sent to the committee. The timeline was not ambiguous. Someone opened that file. Someone applied Code D 47 times. Someone authorized the transmission of a document with 73% of its content redacted. All of this was documented in an FBI-produced log. Whose badge number is shown in this log? Kash Patel, this time without hesitation, responded, I cannot provide personnel information in a public hearing, thereby directly setting a boundary on Jasmine Crockett's questioning, which sought to extend the scope of the inquiry from past statements to the current witness, based on privacy grounds. But Crockett wasn't asking for a home address. He was asking about the person who accessed a federal investigation file subpoenaed by Congress just hours before it was sent, 73% redacted. This is not a question of privacy. It is a question of accountability. Director Patel, this is a matter of oversight, not confidentiality. Patel whispered to his lawyer. He repeated his answer. I cannot provide that information in this setting. I can't provide it. It's not that I won't provide it, I can't provide it. According to the terms of the subpoena issued by this commission 14 days ago, Crockett said, his voice calm and steady, I will submit a written request for the identity of the person associated with this badge number. You will have 72 hours to respond. 72 hours. 3 days. Not by request, but by the deadline.
But the real critical point was this. Jasmine Crockett went a step further by bringing up Kash Patel's public statement from 2 years ago, thereby not limiting the discussion to just the current testimony, but directly confronting past statements. Director Patel, you stated 2 years ago that the FBI applied consistent and appropriate classification standards when conveying investigative materials to Congress. Do you remember that statement? I made many statements over the years. The specific one, the transcript is here. The office applies consistent and appropriate classification standards to every document transmitted to Congress. No selective editing, no political evaluation. End of quote. He placed the document on the table. Is this your statement for today as well? Is this your statement for today as well? The trap was now visible. If Patel says yes, he would have to explain why Code D appeared 47 times in a single witness statement while it was never seen in similar documents from the same investigation. If he says no, he contradicts his own statement and admits that some documents were treated differently. He was caught between the two. Patel spoke carefully. Classification decisions are made based on the content of the material at the time of review and relevant legal standards.
It wasn't. It wasn't a no either. It was a pretext disguised as an explanation. Do you trust the director's statement that consistent classification standards are being applied? Yes or no? 5 seconds. 10 seconds. The lawyer was typing quickly. I support the integrity of the office's classification process, Patel finally said. Crockett leaned forward. Then explain this to me. Why was 73% of a witness statement accessed hours before it was conveyed by a person whose identity you refused to disclose, redacted based on a note you say you didn't review under a code you say you didn't recognize? Then explain this to me. Why was 73% of a witness statement redacted hours before it was communicated by a person whose identity you refused to disclose, based on a note you did not disclose you reviewed, under a code you did not disclose you knew? That sentence contained everything. Patel opened his mouth. He closed it. He looked at his lawyer. The lawyer leaned forward, whispered, and pulled back. And then Patel said something that no one in the room was expecting. I am invoking my right not to answer questions that may affect ongoing law enforcement activities. The room fell silent. It's not a normal pause silence, a striking, heavy silence. Patel had not mentioned the Fifth Amendment by name, but the language he used was Fifth Amendment language, the right not to incriminate oneself. And this right typically goes unseen in the oversight hearings on document classification. Crockett allowed a moment of silence to settle. Then he turned to the president.
For the records, the witness relied on the Fifth Amendment protections in response to a procedural question about document processing. The president nodded in approval, and with that, he closed the Crockett folder. He didn't ask any more questions. There was no need for that, because that stay order was the answer itself. When a witness invokes the Fifth Amendment while answering the question of who authorized a document destruction, the inference is unavoidable. Either answering the question will expose him to criminal liability, or someone else. Both options indicate that there is something indefensible in the process of the blackout. A small correction needs to be made here. While congressional investigations are robust, a strict obligation like names must be provided within 3 days or contempt automatically begins does not generally operate so mechanically in writing. The process usually progresses through negotiation, additional correspondence, and formal committee votes when necessary. We can express the text in a single sentence with a more realistic Congress language, like this. The process triggered by Jasmine Crockett's question either created pressure on the Federal Bureau of Investigation to explain who accessed a specific file and under what authority, or, if this explanation is not provided, laid the groundwork for the committee to consider formal sanctions, including contempt, at a later stage. You don't need party politics to understand what's happening here today. You only need to look at these 4 documents. Document 1, 73% redacted witness statement. 73% of what he said about financial transactions was deleted before it reached Congress. Document 2, privilege log. Every single financial reference was redacted under Code D, which Director Patel said he was unfamiliar with. Document 3, internal memo. The process explaining exactly how the code in question is to be implemented. The note that Director Patel said he couldn't remember. Document 4, chain log. Less than 3 hours before the last access to the redacted version. The badge number that Director Patel said he could not provide. 4 documents, 4 questions, 4 different forms of denial. And finally, the Fifth Amendment. Crockett obtained this not through speculation, but through documents. Not with claims, but with questions. Not with theatrical outbursts, but with deadlines. And now, the countdown has begun. 72 hours. For the FBI to comply or reject. Somewhere inside the FBI headquarters, someone already knows the answer to this question. Someone knows who accessed that file at 9:47.
Someone knows who applied code D 47 times. And within 72 hours, that name will either be disclosed to Congress or the FBI will have to explain in court why providing it would lead to criminal exposure. The documents decided. The timeline decided. The Fifth Amendment resilience has decided. Subscribe now and turn on notifications, because when the 72-hour period is over, you'll want to know immediately. This is not over. This is just the beginning.